Farai Hove Masaisai, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago. I will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
Farai Hove Masaisai.
Good evening, everyone. This is my maiden innings. And I would start by just saying thank you to the Honourable Opposition Leader Penelope Beckles-Robinson for the faith she has had in me to serve in this august House. I'll probably start off where my friend, the Minister of Labour, ended. And I would agree that the journey of 1,000 miles has to start with at least one step. So I too support the codification of the law. So it's a good start. It's a good start. It's an attempt to codify the common law. Now, anyone who knows me knows that I don't practice criminal law, so I would not try there, but I do practice constitutional law, and I do practice civil law. So I'll go to where I think I'm stronger. Now, when we look at the constitutional element of this bill, obviously we have heard for the evening the issue of proportionality. And I would suggest that the Act does have inbuilt in it proportional elements. So it's not really an Act that paints all thieves as murderers and all murderers as thieves. It is an Act that it sorts the balance, have a balance. And as the Attorney General started off the debate, he was clear to say that this does not follow the Florida laws, as well as the Honorable Attorney General gave the example of if you're in your house behind your burglar proof and you see the person in the yard, you're not going to just shoot them because you're in your house, you're behind your burglar proof. So the Act itself does not define all thieves as murderers and all murderers as thieves, because then that would be unconstitutional, because it would not be proportionate. Now, what stood out for me when I was looking at the Act was the section 9(1)(d). And in 9(1)(d), it exempts a person against whom the force is used or threatened is a member of law enforcement authority who enters or attempts to enter the dwelling house in the lawful execution of duties. And as a constitutional attorney, what do we do when the intruder is the police? That's a serious question that the Act itself needs to answer. Because in many communities, deprived communities at that, there's the real instance when police do their dawn raids and they kick down people's doors and they arrest them, probably 3 in the morning, 4 in the morning. They like to do their little operations on a long weekend. Sometimes they go in plain clothes. So you may not know that the person kicking down your door is a police officer. Are they exempt? Now, I would say no, under the Constitution, they're not exempt. Because the Act itself says They have to be lawfully executing their duties. Now, I'll take the time to read from a real-life case. And this case, this is a judgment from Madam Justice Eleanor Joy Donaldson Honeywell. She's now a Court of Appeal judge. She's the former Solicitor General. But as she then was in 2020, she gave a judgment in Alyssa Morgan and the Attorney General. And the judgment starts, the claimant, Alyssa Morgan, a trainee employed with the State Health Service, was arrested at her home hours before daylight dawned one morning in the year 2016. She was detained in a police vehicle driving for hours to pick up male prisoners who were kept in the tray of the vehicle. Eventually, she was driven to a police station and imprisoned for several hours. The arrest was on a warrant for a default of paying $100 on an outstanding $1,000 traffic ticket, as a sanction for which the claimant was to be imprisoned for 9 days. The ticket payment was due to not wearing a seatbelt, almost 4 years before the arrest, when the claimant was a child. As it turns out, the $100 had been paid by the claimant's mother many years ago. It was paid about a month after the arrest, just a few days past the due date, and after the warrant was issued for her arrest. On the night of her arrest, 4 years later, the claimant attempts to explain to the police officers who came to arrest her that she had paid the full amount due with no avail. She seeks by this claim compensation for breach of constitutional rights to personal liberty and security of the person. The court determination based on the analysis above is that the actions of the officers in the instant case was a breach of the Constitution, and the defendant was not protected by Section 49 of the Police Service Act in the circumstances. The events of this case reflect gross incompetence, both in keeping track of paid fines and in the process of addressing suspected non-payment of a fine for minor offenses. The case reflects unfair treatment of the claimant, who was arrested based on a warrant that ought to have been recalled many years ago. She was innocent of the suspected offense. There was an unjustified breach of her right to liberty and security of the person. The failure of the defendant to put into place a proper system to ensure that warrants are recalled once outstanding fines are paid caused an unacceptable breach of the claimant's constitutional rights. The approach of the police of seeking, based on an unrecalled warrant, to arrest the claimant at a time before dawn, when any response she gave to the allegations that she had not paid the fine could not be verified, was also unacceptable. It is clear that the warrant was executed in an untimely manner, without due diligence, without deference to the constitutional rights of the claimant, and without proportional exercise of a discretion in the circumstances where she truthfully said the fine had been paid. Now, I read this for emphasis because many poor people face this daily in Trinidad, where police officers abuse their power. And we have here a real instance where the home invader was the police, and they infringed the constitutional rights of the homeowner. So I asked the Honorable Attorney General to look at that. Now, this act, certainly, we put the victim first. And what I'd ask the Honorable Attorney General, Mr. President, is that when we put the victim first, we put a system in place to allow the victim to have an expeditious hearing. In other jurisdictions, they call it a pre-trial immunity hearing. So it saves the victim from having to wait for a long trial. You know, so yes, I protected my home, I protected my property, I protected my wife, my children, but now I'm sitting in a cell with other prisoners who are there for the common crimes. So pardon? If you put it in, well, I can't, I have to stick to the whip, but anyway, but it's a suggestion. Respectfully, I'm suggesting if we can put that, in the act. It certainly will support the victims. Yes. So, when we look at the weaknesses of the Act, there's the potential for the excessive use of force, despite the proportionality requirements, the removal of the duty to retreat, and the broad allowance for deadly force based on the honest belief may lead to situations where excessive or unnecessary force is used, especially in ambiguous circumstances. The test with regards to the honest belief certainly is a subjective test. And what I am seeing now, when you have the subjective test mixed with an assistant, meaning the Good Samaritan, who helps you to protect your property, is it that the test is the test of the homeowner or the test of the Samaritan in terms of having that honest belief? You may have someone in your home that is your friend, and your friend might be a bit irrational, and they might exercise a certain level of force that you may not, as homeowner, exercise. So in the Act, it leaves that ambiguity. Now, in the Act, one of the things I did not see in the Act is any accommodation for victims of domestic abuse. And I think it would have been an opportune time to put something in the Act to protect those who may have to defend themselves in their own house from someone who is violent, but they are in an intimate relationship with them. So that's something that I've seen in others, but I did not see in our version. But it's something that we could consider, respectfully. All right. One of the things that I wanted to just emphasize as well is the issue of persons with mental disabilities. And my little friend, Senator Roberts Rajman, she gave the real example, and I think that happened last year, where the elderly gentleman had Alzheimer's and unfortunately went to his neighbor's house. And it was this year, yes. And unfortunately, his neighbor killed him. That is a real situation. You know, so we have to, yes, those are vulnerable persons who may themselves become trespassers or intruders in other persons' home, but through no fault of their own, meaning they suffer from a mental disability under the Mental Health Act. The Act needs to make provisions for those persons who may wander off and have no intention to create harm, but obviously they may be trespassing on someone else's property. And finally, the definition, in the definition sections of the Act, under the vulnerable persons, I would suggest to the Honourable Attorney General if we actually include children in the vulnerable persons definition, because it's already there in terms of the fines at the end, grouped with vulnerable persons. But we can specifically say that in the definition of vulnerable persons, apart from persons with disabilities and that sort of thing, children who probably under a certain age. And with that short contribution, I thank this August House.
Honorable Senators, I'd like you to join me